Section 1. The legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. When we say legislative power, we mean the authority granted by the Constitution to make laws and then amend and repeal them as needed. It refers to statutes, which are written enactments of the legislature that govern the people's relations with one another or with the government and its agency. 2. The Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines, as may be provided by law. The Senate shall be composed of 24 senators chosen by the people at large by qualified voters in the Philippines, as provided by law. The House of Representatives shall be composed of no more than 250 members, except as otherwise specified by law, that have at least 20% of them that are party-list representatives. Section 3. No person shall be a senator unless he is a natural-born citizen of the Philippines, and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and a resident of the Philippines for not less than 2 years immediately preceding the day of the election. To be qualified to vote as a senator, you must be a natural-born Filipino citizen, a registered voter, a resident of the Philippines for at least 2 years prior to the election day, and at least 35 years old. Section 4. The term of office of the senator shall be 6 years and shall commence, unless otherwise provided by law, at noon on the 30th day of June next following their election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term of which he was elected. No senator may serve with over 2 consecutive terms. Voluntary revocation of the office for any length of time shall not be considered a break in his service for the rest of the term for which he was elected. Section 5. 1. The House of Representatives shall be composed of not more than 250 members, unless otherwise fixed by law, who shall be elected from legislative districts apportioned among the provinces, cities, and the metropolitan Manila area in accordance with the number of their respective inhabitants, and on the basis of a uniform and progressive ratio, and those who, as provided by law, shall be elected through a party-list system of registered national, regional, and sectoral parties or organizations. 2. The party-list representatives shall constitute 20% of the total number of representatives, including those under the party list, for 3 consecutive terms after the ratification of this Constitution. 1/2 of the seats allocated to party-list representatives shall be filled, as provided by law, by section or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. 3. Each legislative district shall comprise as far as practicable, contiguous, compact, and adjacent territory. Each city with a population of at least 250,000, or each province shall have at least 1 representative. 4. Within 3 years following the return of every census, the Congress shall make a reapportionment of legislative districts based on the standards provided in this section. According to this section of Article 6 of the Constitution, the House of Representatives is composed of 250 representatives or congressmen. The House of Representatives is also made up of representatives from various provinces, cities, and party lists. During the election, registered voters in the Philippines elect members of the House of Representatives. A province or city must have at least one representative in Congress who represents the people if it has at least 250 constituents. Section 6. No person shall be a member of the House of Representatives unless he is a natural-born citizen of the Philippines, and on the day of the election is at least 25 years of age, able to read and write, and except the party list representatives, a registered voter in the district in which he shall be elected, and a resident thereof for a period of not less than 1 year immediately preceding the day of the election. Section 6 is self-explanatory. The qualification of members of the House of the Representatives is that he is a natural citizen of the Philippines on the day of election, that he is 25 years old, that he must be able to read and write, that he is a registered voter, and that he has lived in the district where he will be elected for at least 1 year. Section 7. The members of the House of Representatives shall be elected for a term of 3 years, which shall begin, unless otherwise provided by law, at noon on the 30th day of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. A House of Representatives member may not serve more than 3 terms in a row. Voluntary renunciation of the office for any period of time shall not be considered a break in his service for the entire term for which he was elected. Section 8. Unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on the second Monday of May. Next year, on the second Monday of May, there will be an election, encouraging people to register and vote for the right person in that position, who has political will, who can help the people, and the regular election of senators and representatives, and we have these 2 types of elections for members of Congress. The first is the regular election, which is held on the second Monday, and the second is a special election, which may be called if a vacancy in the Senate or House of Representatives occurs, to fill such vacancy in the manual prescribed by law. Section 9. In case of vacancy in the Senate or in the House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law. But the senator or member of the House of Representatives thus elected shall serve only for the unexpired term. The Constitution states that when vacancies occur in the representation, the executive authority shall issue writs of election to fill such vacancies. House vacancies can occur as a result of death, resignation, declination, withdrawal, or House action. But the Constitution requires that they be filled through an election. Section 10. The salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives approving such increase. There will be no salary increases for senators or representatives until all senators and representatives in the House have served their full terms. As a result, the reason for the delayed effect of increased salary is to put a legal barrier in the way of legislators succumbing to the natural temptation to raise their salaries.
Section 11. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof. In all offenses, a member of Congress is immune from arrest while Congress is in session. Men are not punished by more than 6 years in prison for criminal or civil offenses. Privilege is intended to ensure representation of the member's constituents by preventing attempts to prevent him from attending sessions.
All members of the Senate and the House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interests. They shall notify the House concerned of a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. All members of the Senate, including the House of Representatives, shall make their financial and business interests disclosed to avoid conflicts or issues that may arise. They should prepare what are the possible misconceptions from the filing of proposed legislation because they are also responsible for it. No senator or member of the House of Representatives may hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries, during his term without forfeiting his seat. Neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. There shall be no senator or any member of the House of Representatives holding any affiliations outside their office. He or she should only focus on his or her political duties without engaging with other agencies that could affect their work. No senator or member of the House of Representatives may represent himself or herself in any court of law, electoral tribunals or quasi-judicial, or other administrative authorities. During his term of office, he should not have any financial interests, either directly or indirectly, in any contract with, or in any franchise or special privilege granted by the government, or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary. He may not intervene in any issue before any government office for monetary gain, or if he may be called upon to act because of his position. Section 15 states that unless a different date is set by the law, the Congress shall convene once a year on the fourth Monday in July for its regular session and shall remain in session for a such number of days as it may determine until the 30 days before the opening of its next regular session, excluding Saturdays, Sundays, and legal holidays. A special session can be called by the President at any moment. The senators have their own right to elect their own president, and the House of Representatives is the Speaker. Each house has rules that needs to be followed, and they have the right to punish its members due to misbehavior. They will be given a consequence based on their violation. Each house should also keep a record of its proceedings, or it can also be called as minutes of the meeting. The Senate and the House of Representatives will each have an electoral tribunal that will be the only judge of all challenges pertaining to their respective members' election, returns, and qualifications. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be Supreme Court justices appointed by the Chief Justice, and the remaining 6 shall be the members of the Senate or House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and parties or organizations represented under the party list system. The chairman of the electoral tribunal will be the senior justice. A commission on appointments shall be composed of the president of the Senate, who will serve as ex officio chairman, 12 senators, and 12 members of the House of Representatives, who will be elected by each house on the basis of proportional representation from the political parties and parties or organizations represented under the party list system. The Commission will make decision based on a majority vote of all members. The electoral tribunals and the Commission on Appointments should be constituted within 30 days after the Senate and the House of Representatives should have been organized with the election of the President and the Speaker. Within 30 days after the Senate and House of Representatives have been formed with the election of the President and Speaker, the electoral tribunals and the Commission on Appointments must be established. The Commission on Appointments shall convene only while the Congress is in session, at the call of its chairman or a majority of all of its members to carry out the duties and tasks delegated to it herein. The records and books of accounts of the Congress shall be preserved and be open to the public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. Records and books of accounts of Congress shall be preserved and audited by the Commission on Audit to avoid corruption and to check the expenses of each member. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. The heads of departments may, upon their own initiative, with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance.
The Congress, by a vote of 2/3 of the both houses in joint sessions, assembled voting separately, shall have sole power to declare the existence of state of war. The Congress shall have sole authority to declare of state of war by a vote of 2/3 of both houses in joint sessions assembled. Voting separately, such power will expire on the next adjournment of the Congress, unless they are withdrawn sooner by a resolution of Congress. In times of war or other national emergency, the Congress may, by law, authorize the President for a limited period of subjects to such restrictions as it may prescribe. The exercise powers necessary and proper to carry out declared national policy, unless sooner withdrawn by resolution of Congress. Such powers shall cease upon the next adjournment thereof. The House and Senate, collectively known as Congress, may make up the legislative branch. The legislative branch is in charge of making all laws, declaring wars, regulating interstate and international commerce, and controlling taxing and spending policies, among the other things. All appropriation revenue of tariff bills, bills authorizing increase of public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur amendments. An operation also known as supply bills or spending bills is a proposed law that authorizes the expenditure of government funds. The Congress may not increase the appropriation recommended by the President for the operation of government as specified in the budget. The form, content, and the manner of preparation of the budget shall be prescribed by law. Congress may not increase the appropriation for executive department, legislative, judicial, and congressional bodies. Neither Congress nor the judicial departments can increase their budget. It is unlikely that the judiciary will be cut. No provisions or enactment shall be embraced in general appropriation bills, unless it relates specifically to some particular appropriation therein. Any such provisions or enactment shall be limited in its operation to the appropriation to which it relates. A rider is a provision or enactment inserted to a general appropriation bill that has nothing to do with specific appropriations. The procedure in an approving appropriation for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. This protects the Congress from abusing or misusing its appropriation authority. A special appropriation bill shall specify the purpose for which it is intended, and shall be supported by funds actually available as certified by the National Treasurer, or to be raised by a corresponding revenue proposed therein. Requirements for special appropriations legislation. The Constitution mandates the following. It should specify intended use. It should be backed up real funds as certified by the National Treasurer. Obligations to maintain balanced budget. The Constitution requires that expenditures remain within bounds of revenues. No law shall be passed authorizing any transfer of appropriations. However, the President of Senate, the Speaker of House of Representatives, the Chief Justice of Supreme Court, and the Heads Constitutional Commission may, by the law, be authorized to augment any item the general appropriations law for their respective offices from saving in other items their respective appropriations. Discretionary funds appropriated for particular official shall be disbursed only for public purposes to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. When appropriation for discretionary funds allowed, when it is not possible to determine in advance when expenditure must be made, the precise amount required and the funds intended use. Conditions for discretionary funds include the following. The disbursement must be for public purposes. The disbursement must be accompanied by appropriate vouchers, and the disbursement must be adhered to any guidelines prescribed by the law. If by the end of any fiscal year, the Congress shall have failed to pass the General Appropriation Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Fiscal year is the calendar begins on the 31st day of January and ends on the 31st day of December. Every bill passed by the Congress shall embrace only one subject which shall be expressed by the title thereof. The constitutional requirement serves the following purposes: to avoid legislations that haphazards or log rolling, to protect the legislature from surprise or fraud, to educate the public via such publications. What is a hodgepodge or log-rolling legislation? Refers to any piece of legislation that combines several unrelated subjects. No bill passed by either house shall become a law unless it has passed 3 readings on separate days, and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies the necessity of immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. The purpose of Bill's 3 reading is as follows: to avert rash and ill-advised legislations as well as railroading of bills, to compel a thorough examination of proposed legislation. The journal yeas and nays serve the following purpose: to imbue each member with accountability for his or her legislative actions, to establish conclusively whether or not the bill received the required majority vote. Every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it; otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. If, after such reconsideration, 2/3 of the members of the House shall agree to pass the bill, it shall be sent together with the objections to the other houses, by which it shall likewise be reconsidered. And if approved by 2/3 of the members of the House, it shall become a law. In all such cases, the vote of each house shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in his journal. The President shall communicate his veto of any bill to the houses where it originated within 30 days after the date of receipt thereof; otherwise it shall become law if he had signed it. Bill is a draft of a law submitted to consideration of a legislative body for its adoption. Statute is the written will of legislature as an organized body expressed according to the form necessary constitute into law act. The President shall have the power to veto any particular items or items in the appropriation revenue or tariff bill, but the veto shall not affect the items or items which he does not object. Veto is a Latin term for I forbid or I deny, purpose to enable the executive department to protect its integrity as an equal branch of the government, to provide check on basely corrupt or ill-considered legislation. The rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. Uniformity in taxation means that all taxable articles or properties of the same class shall be taxed at the same rate. Equity in taxation requires such a propping be more such less in just light in the taxpayer's ability to shoulder the tax burden. Progressive taxation, the tax increases as the amount income increases. The Congress may by law authorize the President to fix within specified limits, and is subject to such limitations. The restriction as it may impose tariff rates, import, export quotas, tonnage, and warfare dues, and the other duties are imposed within the framework of the national development of the government. Charitable institutions, churches, and patronages or convents appropriate thereto, mosques, non-profit cemeteries, and all lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purpose shall be exempt for taxation. Tax exemptions. All revenues and assets of non-stock, non-profit education institution used actually directly and exclusively for educational purposes. Proprietary educational institution including those cooperatively owned. Grants and donation used actually directly and exclusively for donation purposes. No law granting any tax exemption shall be passed without the concurrence of a majority of all members of the Congress. No money shall be paid out of the treasury except in persons or of appropriation made by law. The power of appropriation acts as a legislative check upon the disbursing of power of the president or heads of departments and executive officials. No public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, of system religion, or priest, preacher, minister, or other religious teacher, or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or any penal institution, the government, orphanage, or leprosy. Prohibition is not violated when payment is given as compensation given to the priest who is assigned to the armed forces. Religious use incidental. The use of public streets for religious processions, masses at the Rizal Park, and benefits from SS to the priest. Use of public nature for postage stamps and the purpose to advertise the Philippines and not favor any particular church. Payment based on contract rents are paid for a portion of a church or other buildings that is being leased by the government. Consideration received exchange of donations from church to the government. All money collected on any tax levied for special purposes shall be treated as special fund and paid out for such purposes only. If purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided by the Constitution its advised concurrence. The Supreme Court gives weight to the cases that should be elevated for further reviews by the factual findings of the lower court. No law granting a title of royalty or nobility shall be enacted. Prohibition against granting title of royalty or nobility. It consistent with the declaration that the Philippines is a democratic and republican state. It prevents the creation of privileged class which may transmit their classification by inheritance to their children. Validity create titles of royalty or nobility and confer them to the visiting dignitaries of the Congress. The Congress shall, as early as possible, provide for a system of initiative and referendum, and the exceptions therefrom, whereby the people can directly propose and enact laws or approve or reject any act or law, or part thereof, passed by the Congress or local legislative body after registration of a petition therefore, signed by least 10% of the total number of registered voters, of which every legislatively district must be represented by at least 3% of the registered voters thereof. Initiative, it is the reserved power of the people directly to enact the law. Referendum is the process by which any act or law thereof passed by the Congress or by a local legislative body or is submitted to the people for their approval or disapproval.
Article 7. Executive Department.
Section 1. The executive power shall be vested in the President of the Philippines. The President is the head of state and head of the government and functions as the Commander-in-Chief of the Armed Forces of the Philippines. As Chief Executive, the President exercises control over all the executive departments, bureaus, and offices. Section 2. No person may be elected President unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Section 3. There shall be a Vice President who shall have the same qualifications and terms of office and be elected with and in the same manner as the President. He may be removed from the office in the same manner as the President. Section 4. The President and the Vice President shall be elected by direct vote of people for a term of 6 years, which shall begin at noon on the 30th day of June, next following the day of the election, and shall end at noon of the same date 6 years thereafter. The President shall not be eligible for any re-election. No person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. No vice president shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as interruption in the continuity of the service for the full term for which he was elected. Unless otherwise provided by law, the regular election for president and vice president shall be held on the second Monday of May. Section 5. Before they enter the execution of their office, the president, the vice president, or the acting president shall take the following oath or affirmation. I do solemnly swear that I will faithfully and conscientiously fulfill my duties as President of the Philippines, preserve and defend its Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. Section 6. The President shall have an official residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. Section 7. The President-elect and the Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a President shall not have been chosen, the Vice President-elect shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or shall have become permanently disabled, the Vice President-elect shall become President. Where no President and Vice President shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or a Vice President shall have been chosen and qualified. The Congress shall by law provide for the manner in which one who is to act as President shall be selected until a President or a Vice President shall have qualified in case of death, permanent disability, or inability of the officials mentioned in the next preceding paragraph. Section 8. In case of death, permanent disability, removal from office, or resignation of the President, the Vice President shall become the President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the President and Vice President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected and qualified. The Congress shall by law provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified, and be subject to the same restrictions of powers and disqualifications as the acting President. Section 9. Whenever there is a vacancy in the office of the Vice President during the term for which he was elected, the President shall nominate a Vice President from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. Section 10. The Congress shall at 10 o'clock in the morning of the third day after the vacancy in the offices of the President and Vice President occurs, convene in accordance with its rules without need of a call and within 7 days, and act a law according for a special election to elect a Vice President and Vice President to be held not earlier than 45 days nor later than 60 days from the time of such call. The bill calling for such election shall be deemed certified under paragraph 2, section 26, article 6 of this Constitution and shall become law upon its approval on third reading by the Congress. Appropriations for the special election shall be charged against any current appropriations and shall be exempt from the requirements of paragraph 4, section 25, article 6 of this Constitution. The convening of the Congress cannot be suspended, nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Section 11. The President transmits to the President of the Senate and Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits a written declaration to the contrary, the Vice President acts as acting President. Meanwhile, if a majority of all the members of the Cabinet transmit within 5 days their written declarations that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. If the Congress within 10 days after receipt of the last written declaration, or if not in session, within 12 days after it is required to assemble, determines by 2/3 vote of the both houses, voting separately, that such inability exists, the Vice President becomes acting President. Otherwise, the President continues in office.
Section 12. In case of serious illness of the President, the public shall be informed of the state of his health. The members of the Cabinet in charge of national security and foreign relations and the Chief of Staff of the Armed Forces of the Philippines shall not be denied access to the President during such illness.
Section 13. The President, Vice President, members of the Cabinet, and their deputies or assistants shall not hold any other office or employment during their tenure. They shall strictly avoid conflict of interest in the conduct of their office. The spouse and relatives, by consanguinity or affinity within the fourth civil degree of the President, shall not be appointed as member of the constitutional commissions or the office of the Ombudsman. Section 14. Appointments extended by an acting President shall remain effective unless revoked by the elected President within 90 days from his assumption or reassumption of office. Section 15. 2 months immediately before the next presidential elections and up to the end of his term, a President or acting President shall not make appointments except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Section 16. The President shall nominate and appoint the heads of the executive departments, ambassadors, other public ministers, and consuls, or officers of the armed forces of the rank of colonel or naval captain, and other officers whose appointments are vested in him by this Constitution. With the consent of the Commission on Appointments, he shall also appoint all other officers of the government, whose appointments are not otherwise provided for by law, and those whom he may be appointed to. Section 17. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Section 18. The President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or to place the Philippines or any part thereof under martial law, within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. The President shall submit a report in person or in writing to the Congress. The Supreme Court may review in an appropriate proceeding filed by any citizen the sufficient of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus or the extension of therefore, and must promulgate its decision thereon within 30 days from its filing. The The suspension of the privilege of the writ of habeas corpus shall apply only to persons judicially charged for rebellion or offenses they inherited, or directly connected with invasion. Section 19. Except in cases of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures. After conviction by final judgment, he shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. Section 20. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board. The Monetary Board shall, within 30 days from the end of every quarter of the calendar year, submit to the Congress a complete report of its decision on applications for loans. Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of the members of the Senate. Section 22. The President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. Section 23. The President shall address the Congress at the opening of its regular session. He may also appear before it at any other time.
Article 8. Judicial Department.
The judicial power or the power to decide shall be assigned in one Supreme Court and in such lower courts as may be established by law.
Section 2. The Congress shall have the power to identify, stipulate, and divide the jurisdiction of different courts, but they cannot take away the Supreme Court's power to hear cases that are listed in Section 5.
Section 3. The judiciary is a part of the government and is not accountable to the legislature. The judiciary is exempt from the legislature's fiscal authority and is able to set its own budgetary priorities.
Section 4, Number 1. The Supreme Court shall consist of a Chief Justice and 14 other associates. It may sit in division of 3, 5, or 7 members. If a vacancy occurs, the court must fill it within 90 days. Section 4, Number 2. All cases that must be heard by Supreme Court en banc, including cases involving the constitutionality of treaties, international agreements, executive orders, etc., are decided by a majority of Supreme Court justices who voted on the case. Section 4, Number 3. Every division of the court will make a decision when a majority of the members of the division agree, and all members of the division who participated in the decision vote for it. If the required number of judges cannot be found, the case will be decided by the entire court. The court cannot change a ruling made by an individual judge of the court unless the entire court agrees.
Section 5. The Supreme Court shall have the following powers. Section 5, Number 1. The court has the power to hear cases involving ambassadors, other public ministers and consuls, and cases related to petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Section 5, Number 2. The court is allowed to review, revise, revoke, modify, or confirm the appeal or file transfer. As the law or court rules may provide, final judgments and orders of lower courts in 2a. All cases where a treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. 2b. All cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto. 2c. All cases involving the jurisdiction of lower courts. 2d. all criminal cases in which a punishment of seclusion is imposed for life or higher. 2E. All cases involving errors or legal issues only. Section 5, Number 3. Temporarily appoint lower court judges to other precincts as required by the public interest. Such temporary appointment cannot exceed 6 months without the consent of the judge concerned. Section 5, Number 4. Order a change of venue or a place for the trial in order to avoid prejudice to justice. Section 5, Number 5. Can publicize rules which concerns the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules provide a simplified and inexpensive procedure for expediting cases, are unified in all courts of the same grade, and must not reduce, increase, or change substantive rights. The rules of procedure for special courts and quasi-judicial bodies shall remain in force unless disapproved by the Supreme Court. Section 5, Number 6. Is allowed to appoint all officials and employees of the judiciary in accordance with the Civil Service Law.
Section 6. The Supreme Court shall have administrative oversight over all courts and their staff.
Section 7, Number 1. No person shall be appointed as a member of the Supreme Court or any inferior collegiate court unless he is a citizen of the Philippines by birth. A member of the Supreme Court must be at least 40 years of age and must have been for 15 years or more a judge of a lower court or engaged in the practice of law in the Philippines. Section 7, Number 2. The Congress shall dictate the qualifications of lower court judges, but no one can be appointed as a judge unless he is a citizen of the Philippines and a member of the Philippine Bar Association. Section 7, Number 3. A member of the judiciary must be of the highest possible integrity, competence, and independence.
Section 8, Number 1. A judicial and bar council is created to oversee the Supreme Court. The council must consist of Chief Justice as chairperson, the Secretary of Justice, and a representative from Congress, a professor of law, a retired member of Supreme Court, and a representative from the private sector. Section 8, Number 2. The member of the council will be appointed by the President and ratified by the Commission on Appointments. The professor of law will serve for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. Section 8, Number 3. The clerk of the Supreme Court is the secretary of the council and keeps a record of its actions. Section 8, Number 4. The regular member of the Supreme Court shall receive a salary that the Supreme Court decides. The Supreme Court makes and must provide its annual budget. Section 8, Number 5. The Supreme Court shall have the authority to recommend candidates for the judicial position. It can exercise other functions and obligations that the Supreme Court can assign to it.
Section 9. The President of the Philippines shall appoint the members of the Supreme Court and judges of lower courts from a list of at least three nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list.
Section 10. The salary of the Chief Justice and of the Associate Justice of the Supreme Court and the judges of lower courts is set by law and cannot be decreased during their continuance in office.
Section 11. Members of the Supreme Court and judges of lower courts shall hold office in good conduct until they reach the age of 70 or are no longer able to perform the duties of their office. The Supreme Court en banc has the power to discipline judges of lower courts or to order their dismissal by the vote of a majority of the members who have already participated in and voted upon the deliberations of the issues in the case.
Section 12. The member of the Supreme Court and other court judges are not allowed to be appointed to any administrative or quasi-judicial functions.
Section 13. When the Supreme Court is deciding a case, all the judges will talk about the case together and then decide if they all agree. A certificate to this effect, signed by the Chief Justice of the Supreme Court, shall be issued and a copy shall be attached to the record of the case and provided to the parties. Any members who took no part in a decision or resolution must tell the group why they did not take part. The rules in a lower collegiate court must be the same as in a middle collegiate court.
Section 14. Every decision of a court shall state the facts and law on which it is based. A decision of a court shall not be refused without stating the legal basis.
Section 15, number 1. The Supreme Court has the power to take cases up to 24 months after they've been submitted or denied. All other courts can take up to 12 months after the case is filed. Section 15, number 2. When a case or matter is submitted to a judge, the judge will decide or resolve it when the last document is filed under the rules. Section 15, number 3. When the corresponding time limit expires, a certificate signed by the Chief Judge or Presiding Judge shall be issued immediately, and a copy of the case or matter transcript shall be sent to the parties. The proof should state why no decision or resolution was made or issued within the above-mentioned time limit. Section 15, number 4. Despite the expiration of the applicable mandatory period, the court must decide the case without prejudice to any responsibility that may have been incurred in consequence of expiration of the time period.
Section 16. The Supreme Court is required to submit an annual report describing their operation and activities to the President and Congress within 30 days of Congress opening each session.